David Breemer joined the Pacific Legal Foundation in 2001 and serves the public interest as a principal attorney in the Foundation's property rights practice group. He has an extensive litigation record, including in state and federal courts concerning the right of property owners to obtain compensation when their property is excessively regulated for a public good. He also focuses on securing federal court jurisdiction over federal property rights claims and defending private property rights in coastal areas. Today he's going to talk about several pending legal cases, including the severance case, to illustrate and discuss the conflicts between private property rights and public beach access, rights that arise when erosion is deemed to have moved a public beach boundary inland and onto or landward of property that was previously in exclusive private use and ownership. Please join me in welcoming David Breemer.
Thank you. And I'd like to thank Susan and everybody else for putting on the conference and inviting me. It's been very enjoyable, and I have to say everything's been easy, getting to the hotel, getting back, the food, and that makes a lot of difference when you're coming from California and you're walking dead like I was yesterday from the jet lag. So I really appreciate it. I want to introduce Pacific Legal Foundation really briefly. Some of you may not have heard of us. The Pacific might throw you off, part of our name, but we're a national organization. We're the largest pro bono law firm dedicated to defending private property rights in the courts, federal and state courts. We're primarily appellate in nature. We do a little trial work now and then, but not very much. And I'm going to give a disclaimer as well. All the cases I'm going to talk about today, I am the lead counsel in those cases. I will try not to go too far towards advocacy. I would like to be more descriptive, but it is hard sometimes to take the advocacy out of the advocate when you've been living with the cases. So you'll have to forgive me if I do that, and I'm well aware that there's two sides to the story. By the way, I was a student of Allison Reeser's 12 years ago, I don't know. At University of Hawaii, so if you don't like anything I say, or you don't like where my career has gone, you can talk to her and blame her, 'cause, what can I say? We're going to be discussing today the conflict between public beach access and developed private property along eroding shores. And specifically what we're going to be focusing on is the dry sand portion of the beach. The portion of the beach that is landward of the mean high tide line or landward of the wet beach. The wet beach to the mean high tide line, low tide in some northeastern states, but generally the wet beach is considered owned by the state. It's held in trust, public trust, for public uses such as access and recreation, and there's not a lot of dispute about that, at least as far as I'm concerned. So we'll be focusing on the dry beach area. And the question is, as erosion pushes the water line inland, can the public acquire beach access over new areas of property that have previously been in exclusive private use and ownership, but have lately come to be dry sand beach areas and closer to the water? We've spoken or heard a little bit about subsidies and whether the public should subsidize rebuilding in disaster-prone areas, and I think that's a legitimate question. We're going to flip it a little bit, though, here, and the question is, should a few property owners subsidize public beach access for the general public when older traditional areas of beach access are under pressure from erosion? The first case we want to look at is Severance versus Patterson. This is a case out of Texas which challenged Texas's rolling easements system. And I'm going to have to explain this a little bit. I know there's not some lawyers in the audience, and a lot of the concepts I'm going to discuss are legal terms, and I will try and illustrate them as best I can so you can understand. The rolling easement idea in Texas is the idea that when the public has acquired an easement over a particular slice of beach land by common law proof. In other words, they go to court. Let me just illustrate. I'm going to walk away from the microphone for a second. It's easier to do this. If the public has walked along this stretch of beach where I am for a significant period of time, back and forth, it can acquire an easement over that area. It has to prove that it's walked on this specific area in court, and if it does, it can get a right of access to that area, regardless of whether the property owner likes it or not. That can happen on your property. It can happen on the beach. It's called an easement of prescription or dedication. Also customary law. The idea of the rolling easement in Texas is that once the state does that in a particular strip between the tide line and vegetation line, that when a storm, erosion, avulsion, which is a sudden erosion, moves the vegetation line that way inland, that the easement will also move that way inland. So if I prove an easement between this and this table, and those tables got moved back there, the rolling easement idea is that the easement would expand, or at least it would replace what was lost to erosion down here. I hope that makes sense. So the Texas promoted this idea for a long time, and it got very ingrained in the culture there. And a whole regulatory system, as I'll show you in a minute, was built upon this idea. It was also justified as a manifestation of the Texas Open Beaches Act. But the Texas Open Beaches Act says this: if the public has a right of use over an area by prescription, dedication, or continuous use, I would add customary law, then the public will have access to the vegetation line. So it was conditional. Nevertheless, the state interpreted this act to mean that there's a rolling easement in Texas, a rolling public access beach easement. And it built up a regulatory system, a land use regulatory system on this very idea. So that any time the vegetation line would move landward, any property that was seaward of that line would be considered public. And then, on that idea, if you have structures on the area seaward of the vegetation line, this is another way of saying is the dry sand. Anytime property suddenly becomes dry sand because it's denuded of vegetation, the state would claim that there's a public easement there. If you have a structure on that area, you're subject to removal without compensation of that structure. Homes can't be repaired after they've been significantly damaged. Landowner cannot exclude trespassers, and on and on. And so basically you have a transfer of property rights at the moment you lose your vegetation. This is Carol Sevent's in her house in 2005, right before Hurricane Rita. No one remembers Hurricane Rita because it was just a little hurricane compared to Hurricane Katrina, which was like a month before Hurricane Rita. She bought her homes as investment properties. This is one of them. There was another one. I don't have pictures of that one. But here it is. You can see it's got a little bit of vegetation in front, and it's her property. This is her property after Hurricane Rita. No vegetation, no damage though. This wasn't a severely damaging storm, but had an erosive effect. Lost some sand, lost the grass. So this is private property. Down below there, this is public property, according to the state. When she purchased her house, I don't want to go over this fact because notice is brought up. When she purchased her homes, there was a disclosure in the contract that said the state customarily views the public beach to extend to the vegetation line, and if your property moves, actually the property can't move, if the vegetation line moves landward of your home, then you might be subject to removal. So after this event, she gets a letter from the Texas General Land Office which says, your homes are on a public beach now because they're seaward of the vegetation line and they could be removed at any time. So she came to Pacific Legal Foundation and we filed a complaint in 2006. One of the claims that she had been subject to an unreasonable seizure of her property. Her specific claim, the specific legal claim that we made was that if once you've proven, it's fine to prove an easement along a strip of shore by public use, but that easement can't jump from point A to point C. It can't move from the area where the public was walking to an area back there, say, inland, where the public has never walked before, at least not without compensating. And moreover, there's no common law, there's no rolling easement in Texas law. There's no rolling easement in the Open Beaches Act. There's no rolling easement, period. So therefore, if you're going to impose public access on private dry sand property that's never been subject to public access before, without compensation and without sanction in Texas law, because there's no rolling easement, then you're unreasonably seizing her property. And you can't do that. So this is being litigated in federal court, and as it's being litigated, Hurricane Ike hits. Now this is a picture of Bolivar Peninsula. This is not where her home was, but I want you to see the extent of the claim under the rolling easement theory would be that everything that has green is private property before Hurricane Ike, and everything that doesn't have green is public property after Hurricane Ike. So when you have on Bolivar Peninsula, the Hurricane Ike was huge. As you know, it stripped away the grass for a long way. And in oral argument, it came up, well, the state would consider all this to be suddenly be public property, which is, as you can see, the water line didn't change that much, but the vegetation line did, and that's a big expanse of land that's all now considered open to public access, unbuildable or unrepairable. This is Severance's home after Hurricane Ike. So it's leaning a little bit. You got a lot more erosion under there. It was one of the only two of front row houses that survived on this strip right here on West Galveston Island. So after Hurricane Ike, her home became unrepairable, unusable. She's got nothing. Her mortgage is ongoing. This, the Fifth Circuit held that she had stated a claim for an unreasonable seizure, subject to the caveat that the court, Fifth Circuit, wasn't quite sure whether this rolling easement was really an accurate manifestation of Texas law or not, and it wanted the Texas Supreme Court to tell it before it reached a final decision. So it certified questions to the Texas Supreme Court about whether, primarily, the rolling beachfront easement is a valid aspect of Texas law. Can there be an easement, this thing that covers private property, without the state having to go through the motions of proving that the public has actually used that property before? And there was several other questions, but they're not really pertinent here, so I'm going to skip over them. Got a couple more cases to get to. So in the Texas Supreme Court, the issue was, is there a rolling easement in Texas law? The case focused on the common law, Texas common law, which is law which, as you know, probably exists outside of statute. The reason it focused on Texas common law and not the Open Beaches Act itself is because the state declined to argue that the Open Beaches Act statute actually creates a rolling easement or imposes public access, because that would be a taking. The state legislature can't just write a statute that says, we're going to put public access on private property. So the state argued that the Open Beaches Act and Texas common law, that the Open Beaches Act codified pre-existing background principles of Texas common law, and the rolling easement was incorporated in that. And the problem that the state had, and in my opinion, or in the court's opinion, one of them was this 1959 decision called Ludes. And that established, in that case, the state tried to argue that the state owned private property to the vegetation line. And the court said, no, you own property to the mean high tide line. That's how far the public trust goes. That's how far state ownership goes inland, to the mean high tide, not farther upland on the vegetation line. So it had already tried to argue it owned the beach to the vegetation line and lost. So that means you're starting from a default premise that anything landward of the mean high tide line is privately owned, which gives the state only a couple options to win this case. You got to prove, it either has to prove on that specific slice of land that they want public access, prove that it was previously used by the public for that period, someone walked along it, and for long enough to create Common law easement, which is hard to do since we're talking about land underneath a home. It's pretty difficult to walk through a home unless you're a ghost. The other way was the state to argue that there's a rolling easement, as I said, that moves when the vegetation is denuded. The Texas Supreme Court rejected the rolling easement theory in a 6-2 decision in November of 2010. It held that the state didn't reserve any rights. There was another way I didn't mention there. When the state grants land into private ownership originally, any private property owner that grants land to someone else can reserve certain rights. So the court considered whether the state of Texas in 1840, when it sold West Galveston Island to private owners, whether it had reserved a right in the public, and it found that it didn't, which makes sense because in 1840 people weren't thinking about public beach access and recreation. They were thinking about wharves and shipping and the economy. Moving on, the court said, okay, that you didn't reserve it, you didn't prove it, and there's no rolling easement in Texas law because we can't find a single decision from prior to the Open Beaches Act anywhere that talks about an easement that rolls or moves with the movement of a boundary marker like vegetation. So there's no rolling easement. If you want an easement, you got to prove it, just like you would prove it on any other strip of land in Texas. And the court repudiated 4 prior Court of Appeals decisions in reaching this decision. And I'll leave it at that. Back to notice a second. Let's get back to notice. As I mentioned, Carol Severance had a disclosure statement. The court addressed that issue. The state argued, look, she knew she was buying this risk. We told her we would consider the vegetation line the beach, and if her home, if they got in front of that or the vegetation got behind that, well, you know, she took the risk. And the argument that was made in response to that is the state can say anything it wants in a disclosure, but if it's not the law, it doesn't matter. Carol customarily viewed her private property rights as extending to the mean high tide line. We understand you customarily view it as a vegetation line. Let's see who's right and try it with free speech. The mayor of Galveston decides that protests are really annoying and inefficient. They take up a lot of police officer time, so they slip a notice into the rental contracts for all apartments in Galveston saying, if you criticize the mayor or have a protest, we're going to boot you out. It's not going to work. In other words, you can't waive your constitutional rights that way. I'm going to move forward quickly on this. There was rehearing. This case was reheard, re-argued. One justice switched sides, Justice Guzman, and she said, interestingly, that she would hold that the public could have access around Carol Severance's home, but couldn't remove her home. So she would sort of split the baby. I'm going to save this, save questions. The holding in Severance that is, the takeaway holding is that the court said, if you move an easement, if you have an easement along the shore and it's subject to gradual erosion, then that easement can gradually move upland. But if a hurricane like Hurricane Ike comes along and strips the land of vegetation, that doesn't move an easement. It's called the avulsion-erosion distinction. Erosion being gradual, avulsion being sudden and dramatic and perceptible wearing away of the land. So that easement in Galveston, there is one, by the way, along Galveston. There was a road there in the 1900s. That easement can move inland gradually with the water as erosion moves it in, but it can't jump because of a storm, a hurricane. All right, now let's move on. This is another case pending in the Texas Supreme Court, Brannan versus State. I'm lead counsel in this case as well. It's been pending in the Texas Supreme Court for 2.5, going on 3 years. Could get a decision any day. And this is Surfside Beach. The waves aren't as good as that. I've been there, and if they were as good as that, I'd be there a lot more probably. But it's a nice place. It's a surfing, for Texas, it's a surfing area. So there's a lot of pressure on the beach for use. This case follows up on Severance in a couple areas. First, it asks It involves the question of, well, what is avulsion? What exactly is erosion? And what kind of events are avulsion, sudden and perceptible? Is it just hurricanes, or some lesser events be considered avulsion? What things can move an easement and what can't? And also, what does the state need to do to actually prove an easement in this context? And if an easement is on your land, this follows up the severance issue that the court didn't reach in severance. Can you remove homes? Let's say the state establishes in Surfside that that it reserved an easement on the dry sand because it's a different title. It's a different title of land. Well, then when that easement comes up onto property owners, can you remove a home? Surfside is below Galveston. You could see right there. I got to get my little thingy going here. Huh? There you go. Right there. There's Galveston. Carol Severance's house was right. This is West Galveston Island. It is right in here somewhere. There's a lot of this that is still undeveloped along Galveston. Big gaps of but Surfside is a very small town down there, and it is located. Looking from your direction to the left of this jetty, you can see both of these jetties right here. And what has happened in Surfside, it's subject to a really high rate of erosion. It hasn't always been that way. And there's a lot of evidence and studies that have been done showing that the problem is that these jetties, one of the problems is that these jetties are stopping the littoral drift, the supply of sand horizontally along the beach. So Surfside, which is over here, is not getting sand anymore. And also, there's a river that goes through here, a shipping port, and the mouth of the river was moved, I believe, in the 50s. Tom Linton, who's here, can probably correct me, but it was moved, and when they moved that, it stopped. It shifted both the lateral flow and also the incoming sediment. Here, the houses in Surfside were built mostly in the 1960s. This is in 1994. We're going to see this house repeatedly. You can see the vegetation. You can see quite a bit of beach out there. 1998, Tropical Storm Francis, September 11th, came ashore. We've seen more pictures than hurricane this conference than I ever want to see. Here's another one. It looks just like the other ones, except it's a different state. The Francis also was not a highly damaging hurricane, but it was highly erosive. This is Galveston Island State Park, which is just to the east of Surfside, and you could see that it wiped away. The structures, even these little structures are basically okay, but it tore up that vegetation. After Tropical Storm Francis, dozens of homes along Beach Drive and Surfside, which is the front row, received letters saying, well, you're on the public beach, you're on this list, we've got the list of homes that are on the public beach, and we're going to send this list, the General Land Office says this, we're going to send this list to the Attorney General for potential removal of the homes. And the property owners, several of them, sued for a declaration that this policy is illegal under state law, it's a taking, that's eviscerating their private property rights. And as soon as they sued, the state counterclaimed in court for actual removal of the homes, didn't wait for the Attorney General to make a decision. And so now you've got a full-fledged controversy. Here are some of the original plaintiffs. The suit was filed in, I believe, 2001. That's about right. So we're going on 11 years now. And this is the Porter family. You see this is their blue house, the same blue house I showed you in 1994. And I believe this is in 2010. It's important to show people, I think, at least in my business it is, because we can talk a lot about macro this and retreat this and move the people and all that, but you're talking about people, actual individuals, and when you go to court, judges are actual individuals too, and they're homeowners, and they care about people. So here you have the Porters. Here there's their home again, 2001, that's why I have this here. There's their home. Here's the vegetation. It's kind of, it's kind of split. You're kind of halfway there. From 2001 to 2006, litigation was ongoing in state court, not federal court. In 2004, there was an enforcement moratorium. The state passed a law saying we're not going to enforce right now removing homes and all that because we're really not sure we want to do this, and there's got to be some other solutions. But the moratorium ended without a solution, and the state came along and said, all right, well, you're still on the public beach. We'll give you $40,000 to remove your home. Call the trucks. They didn't say where to move them, or they didn't pay for the land. So a couple dozen refused. Some agreed. Litigation went on. One of the problems with these types of suits in our judicial system is that while you're litigating the questions, the beach is dynamic, so it's always changing. It continually changes. So here it is in 2006, completely on dry sand, right? Same blue house, completely on dry sand. You can see the public there using it for shade. Or no, there's shades over here. There, you can see the public there. You can see some wind waves out there. But it's all right, you know. It looks like it's working, right? Okay, fall 2006. Just in October 2006, there's what's called a bull tide. If you're not from Texas, you won't know what that is, because I sure didn't. But I learned it's an unusual high tide event that occurs around the equinox. And so here you are, even a month later after September, and you could see there's still a little vegetation there, but not much. This is the line of houses, most of which are in this, or some of which were in the suit at this time. All right, so in 2006, October, a bull tide came ashore and caused more erosion. At this point, this town, with the state's blessing, because in Texas you have to go through the general land office to do anything pretty much if you're just going to do it on the beach. They put up a barricade. They disconnected the electricity and denied all repairs, all permits, said they weren't going to give any more, all protection, no sewer, no water, no access. So basically they're dead in the water. It's terrible. Basically they're dead on the beach. They're like a fish that you've pulled out, and it's, you know, it's just kind of gassing, but you need to get it back in. And so there they are. When the village dumped this, it dumped it right on the water sewer line, so there was no way for them to reconnect if they wanted to. I don't know where it got this stuff, but one of the things in there was a gravestone. You can see that here, and it's it's kind of sad. I hope they. I have no idea what the story. So they got this temporary barrier. It's kind of apropos, but in a sick kind of way. So I don't. Later on, the village just dumped a more permanent barricade. This thing was growing, and because they said their plan didn't contemplate any homes out there, and so they're barricading. The property owners are all they got nothing. So the suit grew. A bunch of property owners intervened and said, "Now I want to sue too." So they joined the lawsuit, Brannan versus State. And it continued its litigation course through the trial court for a long time. Then Hurricane Ike, and here you go. This is what happens, and you've got all these homes are gone. There's the blue house. There it is. It must be the paint. And here's another. This is Marcario Ramirez, his house. He's a native Texan and a Mexican-American who owned a couple properties as a retirement investment. And so all of them except two collapsed. The Porters, the blue house, sadly, it succumbed in 2009. It just couldn't stay up. There's no repairs, there's no protection, so it collapsed. So, but you got a couple that are still left. The suit continues on. In 2000, I'm going to shorten this up. In 2010, the appellate court, Texas appellate court, said the rolling easement is part of Texas common law. This is pre-severance. The rolling easement is part of Texas's law, and it's not a taking, and you're subject to it. And moreover, the state can remove your homes without compensation because you're encroaching on the public beach easement. The public has an unfettered right of use, and your homes are in the way of that. And it's not a taking since you don't really have the property interest. Once the vegetation line moves inland and you're on the dry sand, you don't really have the property interest anymore to support your takings claim because your property is dry sand and it's subject to this public easement. So that was that. It got petitioned, however, to the Texas Supreme Court. And it's pending, as I said there. Here's, in late 2011, here's the Ramirez home still there. There's people that are enjoying themselves under it. Hopefully that, that's, hopefully the baby, that's just a chair. But yeah, they're enjoying themselves under the home. That's probably not where I would be. But it looks like there's good shells. So the homes are still there. The village doesn't want to do anything like it because it's in litigation. So it continues on, and then the state comes along and says, we're going to renourish. Here's the same home, the Ramirez home. And so without going to the property owners or any of that, they just got the bulldozers out and got the sand and planned. They planned for this. It wasn't, that spur of the moment. They planned. And they started renourishing the beach and on Surfside. So they dumping all the sand there and creating this nice new beach. Meanwhile, the homes are staying there. And then in Texas Supreme Court, what the state then did is it claimed, while the case was pending, that the court had no jurisdiction because all of Surfside Beach had come to be submerged land. In other words, it was subject to the mean high tide line. So in other words, it renourished the area, it turned out, because its claim is that it's all subject to the high tide line now, or at least it became that way sometime in 2009. But it didn't provide a survey to the court. It didn't provide a survey to the property owners, and it never even claimed that it used a high tide survey. It just said that we observed that the water line was in, so we concluded that it was submerged land, therefore it's state-owned, therefore we can renourish, and therefore, court, you don't have jurisdiction over this because it's all state-owned property. It's not private property anymore. And so we countered with that the state had waived a right to make this claim because in a previous part of the suit, the state had severed any submerged lands claim. In Texas, you can create a separate cause of action out of your claims. You can actually split claims. So the state said, you know what, we're just going to proceed under the Rolling Easement and Open Beaches Act. We don't even need to go on to this submerged or lands claim, so we're going to create a whole new cause of action. And so that cause of action has been sitting in the trial court doing nothing while this case went up on the Open Beaches Act and Rolling Easement case. So the argument is that it's too late for the state to do it. So the opinion is pending. It could come out tomorrow. Friday is opinion day at the Texas Supreme Court. So who knows? You might see that on the way home. Let's move somewhere else real quick. North Carolina, a little bit closer to home. I really wanted to get to this. These are, I'm going to be discussing two cases, and they're going to focus on these homes right here. This is Nags Head, and one of the homes particularly is right here. That's a little bit farther inland. And these are obviously far. There's some up there too, but these are the ones in the suits. And the central issue in North Carolina, it's very similar to severance, but with a little twist. And that's whether the public trust doctrine, which traditionally covers wet beaches, whether that same doctrine covers private dry sandy areas between the high tide and vegetation line and can migrate as erosion moves those lines inland. And can governments, as in Brannan, once a piece of property or a home comes to be situated on what is considered to be public trust property, dry sand beaches still, can the governments come in and remove those homes so the public can have unfettered access and recreation. The cases we'll be talking about are these three right here. I'm the lead counsel in the first two. The third I'm not, but it is very important because it'll affect the first two likely. They're pending in the Fourth Circuit Court of Appeals. Just want to make that clear. Oral argument will be in end of January. So quickly, the state law background in North Carolina. It's the common law, the case law is very similar to other places. The public trust, the wet beach is covered by the public trust. The state owns it, but it's got to keep it open for public use. No indication in the case law about the dry sand beaches. But in 1998, the state legislature, passed a law which seemed to affirm that the public trust might go to dry sand beaches too. But unfortunately, it was an ambiguous law because they stopped short of actually saying that. They added disclaimer, I would consider it, to saying, but public trust rights in the beaches are established in common law as interpreted and applied by the courts of the state. So you could read it two ways. You could read it as the state saying, legislature saying affirmatively, we want the public trust to go to dry sand beaches. Yes, private property owners, you own it, but it's subject to public access. Or you could read it as the legislature kind of saying that, but then ultimately punting and saying, but we're still going to let the courts work this out. The towns, the local governments in North Carolina, however, have decided to enforce the first view I mentioned, that the public trust under the state law goes to cover dry sand areas. It goes to the first line of vegetation, or the dune line. The town of Nags Head is one of these towns, and they passed a nuisance ordinance which says any structure that is located in a whole or a part on a public trust area is a public nuisance. And as I mentioned, excuse me, I gotta go back. I guess I skipped a slide here. As I mentioned, so they passed a nuisance law saying anything on the public trust is a public nuisance and it can be removed. But they also define the public trust to include the dry sand area. So you gotta take those two things together. In 2009, by 2009, erosion had become a real problem at Nags Head. It's got a high rate of erosion as well. It goes back, it accretes in the summer, in the winter it erodes, but generally there's a trend for erosion, for the beach to recede. And Mayor Oakes campaigned in part on removing certain homes if he was elected in early 2009. He was elected, and right afterwards, a storm came ashore. This was like a zombie or a hybrid. It was a nor'easter and the remnants of Hurricane Ida. And it came ashore, and the owners of the houses, the sand soda houses here, piled sand all along here, and during the storm, and before and during, they had contractors move the sand, especially over their septic, to try and protect it and protect their structure. And this is all permitted by the state, by the way. They had CAMA permits to do this. This is known that they were allowed to do this and had done it before and protected their houses. So they were busy doing that. Meanwhile, a storm is going on. There's a road back here. The road gets damaged, according to the town, and so the town sends out 4 police officers. And the police officers tell the contractors that it's unsafe to be where they are. They need to get behind the road, behind a barricade that had been set up on the road because the road had cracked in certain places or water coming through. So they stopped the protection efforts at high tide, or just before high tide. And this is so the rest of the day the storm goes on and the water comes in and it's just eroding everything and bashing around the homes, and did some damage to the exterior of their decks. And the air conditioning, uncovered the septic, and that type of thing. But they were still repairable, and we'll get to that in a minute. However, 2 weeks later, the property owners got a notice from the town of Nags Head that declared their homes to be nuisances, primarily because they're on the public trust area. They said there's some damage, but the main cause, this came out later, the main cause is that they were considered to be on a public trust area. And that's why the remedy, they were told, is you have to remove your homes. There was no right to cure or to repair their homes. The town said, remove your home, it's on a public trust area, and we will refuse to issue any repair permits if you seek them, and we're going to fine you, I believe $100 per day for every day you don't comply and the home stay. The home stayed, and we'll get to that. The fine is now $600,000 or more. So that's the slide I was referring to. So property owners sued, 6 of them, 6 in the Sand Soda case. They sued. The Teloscos, which was that one house I showed you that was farther in there, they also sued, but they weren't subject to the bulldoze. None of that was part of their case. And The Sansota property owners, they claim that the public trust doesn't go to the dry sand area under state law. The town has no authority to enforce the public trust, even if it does. That's a state duty. Violation of federal constitutional rights, substantive due process procedural, takings, equal protection. Equal protection because the town admitted that there were other homes on the public trust area, in its eyes on the public trust area, but it didn't go after them. So in Telosco, on the other hand, the town sued the Teloscos to remove their home in state court. They removed the case. The town removed in Sansota, so they both end up in federal district court for the Eastern District of North Carolina on all the towns claiming, hey, we have a right to remove, we need an injunction, an order of abatement, and we want fines, and the property owner is saying, no, you don't have any authority, and you're violating our constitutional right, you owe us money. Meanwhile, the cottages sit vacant and unprotected, and here they are. Here's the Telosco cottage, right here. This is in 2010 and 2011. And you can see the difference. This is probably closer to fall or winter, I don't know exactly, and this is probably summer right here. So there's some sand there and none there, really. Here's one of the cottages in Sansota in August 2011. You can see that they've just been sitting there. They've been subject to some damage and vandalism, but mainly they've sat there. There was engineers that came out and checked to make sure they weren't going to collapse. They weren't, but they've just been sitting there unused while the litigation continued. Then, kind of like Brannan, in late August 2011, you can see all the graffiti up here. In late August 2011, the town renourished the beaches, so it dumped a bunch. It created like 150 or to 200 feet of beach in front of them. So there's a Telosco cottage right there. The rest are Sansota. So you have, and I got permission, by the way. I know people don't really do that anymore, but I called this guy and I said, could I use your photo? And he said he was happy to do that. So you have the cottages there, and now you got sand. So the town rescinds its nuisance declaration and says, we no longer are going to consider you a nuisance. Go ahead and apply for repair permits if you want. But keep in mind that we still think you're on the public trust, and we can go after you. We can remove you any time if we think you're interfering with public access. But we won't call you a nuisance anymore. The fines are ongoing, though, however, so it'd be good if you paid us sooner rather than later. And litigation continues. While it's continuing, you have this other case, Cherry. And this Cherry case is this home right here. And in the Cherry case, it went through state courts, and the North Carolina Court of Appeals said to the town, held that the town had no authority to enforce the public trust on North Carolina beaches. It had no authority to remove homes on a public trust ground because the state has that authority. And in the federal district court, the Cherry case was brought up to the court, but the court declined to rely on it too much because the town petitioned the North Carolina Supreme Court. What the federal court ultimately did is it dismissed, in the Sansota case, it dismissed the federal claims, or at least the takings claim is unripe. It rejected the due process and equal protection claims on the merits. In the Telosco case, the court just said abstain, and basically what it said is, this deals with the scope of the public trust and the definition of public beaches in North Carolina, and I don't want any part of that. That's something for the state courts to decide. I'm abstaining from this whole big mess, and I'm dismissing the case. So now it's on appeal to the Fourth Circuit, and what we're arguing is in the Sansota case, the federal claims were either improperly dismissed on procedural grounds, or in the case of the due process claim, particularly procedural, that the town violated the Sansota owners' due process property rights because before they issued the nuisance declaration, said you had to remove your home, imposed fines, and denied repair permits, they didn't give them any kind of administrative hearing, not before or not after the actions were taken. So that's the due process claim. We have not raised the protection of the bulldozing issue. That's not an issue in the Fourth Circuit. We've abandoned that, at least for purposes of substantive due process, because the town has safety defense, health and safety defenses. In the Telosco case, the argument is simply that the federal court can't abstain on these issues simply because there's state law at issue. And the Cherry case comes into play because now that the North Carolina Supreme Court has denied review, that's the law of the land. And the law of the land says, town, you can't remove homes based on the public trust. So that's where we are. And I'm right up against my time because it says sum up. So I'm not going to answer this question. I think Tom Linton, who's from Texas, has done some research on the Severance case, and I think he'll answer the question here. But the ultimate question of whether how you can deal with public access as beaches erode and old public beach parks and areas are covered with water and new sand is exposed. There are ways to do that can accommodate both interests. But I think what you've seen is that sometimes there's a rush. The issue is emotional, and there's a little heavy-handedness sometimes. And so far, at least in Severance, and I think in Brannan, although I don't want to protect, I don't think it plays out that well when towns are rushing to come against homes that aren't seaward of the mean high tide line.
We've got about 10 minutes for questions, and we're going to follow our format of trying to be fair and equitable across the webosphere and across the room. So, David, I'll let you go ahead and field the room, and I'll handle the web.
I think you were first.
Thomas Rupert with Florida Sea Grant. Well, thank you very much for the presentation first. One of the cases you didn't mention that the Pacific Legal Foundation is also involved with is in Florida. It's a case called Trepanier versus Volusia County. It's actually been concluded, but the argument there, while similar to Severance, was a little bit different. There, the argument was that the argument was that there is an easement for public beach access there, based on custom. And the court the Pacific Legal Foundation argued, and the court intimated that, yes, even if the property line does move due to erosion, that it's not necessarily the case that the easement does. And so the argument by the Pacific Legal Foundation was that easement is connected actually more to the let's say the lat-long location as opposed to the beach feature that actually supports the whole reason for the easement even existing. In other words, the easement exists because the public used the dry sand beach, but the easement is not connected to the dry sand beach.
That's right.
Okay, so basically the argument was founded on the fact that they were applying landlocked rules for easements in the coastal context. Now, part of the question then is that appropriate to apply landlocked easement rules in the coastal context, even though we have very different property laws in many instances for coastal properties due to the unique nature of the coastal environment? Second, even if you do apply landlocked easement rules, there is an argument that easements are also very often interpreted in order to accomplish their ends. And that in this case, it would make sense actually to have that easement attached to the feature rather than the geographic coordinates, because otherwise, aren't we actually guaranteeing the loss of all these public beach access easements that have been established by custom? Because these beaches are going to move. And it's a little disingenuous to say, I think, that, oh, well, you just reprove the easement. Well, we both know that proving those easements requires demonstrating use since time immemorial or some other such formulation. And we obviously, as you noted, can't do that underneath a house that now exists there.
Okay, let me try and, there was a lot in there. I'll try and get to that. Okay, landlocked rules. Are we applying should we apply landlocked rules to the beach? I guess one of the answers is that the Constitution applies regardless of whether you're inland or you're on the shore in that context. So I don't see the landlocked seashore distinction being dispositive. But let's move to easement rules. Until courts craft or states pass laws that creates that does away with the traditional rules for easements, you can't just get around them. They exist out there, and they don't depend on whether you look. If let's just forget about just for a second. If I lose my vegetation on my property and it turns into dry sand, you might think beach, but I might think, well, I don't have a garden anymore. I just have a sandy lot. So, nature didn't turn my property into a public beach. That has to be done by some affirmative action of the state, and the Constitution and the rules for doing that are going to govern. Should the easement purposes control? The purposes of easements control in a situation where say you have property and you decide you want to sell it off to a subdivider, but you reserve an easement for a specific purpose. Then the purposes will control the easement, and the easement will go and do whatever is necessary for that purpose. But when you have an easement that's created by public use and walking along a particular area, that easement is going to be created and defined by the public use. Now that doesn't mean it's static. Easement law allows easements to move as public use varies. So if an obstacle comes down, or a tree or whatever comes in front of you, the easement can move around to avoid that obstacle. Easements aren't completely inflexible, and that's not our claim. In Severance, for instance, the reason the erosion-avulsion distinction makes sense, an easement proven by public use can move by erosion and not by avulsion, is because it keeps the easement tied to the line of public use. If it's gradual, the public is gradually moving above the water line, walking a little bit more inland on the area, walking a little more inland, and so that makes sense. But if you're going to say that a storm is going to push the vegetation way back there, and now they're walking on first, second, and third row of homes where no one has ever walked, well, then you're completely divorced from the thing that made the easement. That's a long way of loss of public beaches. That was a claim made on rehearing of Severance time and time again. Look, there are a lot of states that have a lot of public beaches, and they don't need a rolling easement or to impose it outside the law or without compensation, without buying easements, without consent. There are a lot of ways to do it. The problem in Texas is they got used to doing it, in my opinion, and getting for free. So that the idea came in that, hey, anytime there's new dry sand, that's ours, regardless of how long ago it was developed, how long ago it was used. And I don't see why, as a policy matter, you need to do it that way. There's lots of other ways. The Trepanier case, I'm just going to breath that. That was a case, and our claim was very similar to Severance. And that's simply, if you want public access on a particular area, you got to prove it on that area. You can't, there's no public trust in dry sand. And, we'll find out in North Carolina, but there's not. And if you're going to impose one in there, then it's just like passing a statute saying that your property is ours. Yes?
This is going to be our last question. I'm sorry, guys.
So, if possible, I'd like to ask you two hypotheticals, and they're in my mind, really important ones. One is a private property gets stranded on the wet beach. Does the public trust doctrine apply? Is that owner entitled to compensation under the Fifth Amendment? That's part one. If
you have a structure that's wholly on the wet beach, the mean high tide line, and that's the definition of public trust, I'll say it this way: that's not a case PLF would take.
Okay, that's good to know. So that's one. And then my second one is, say you have that same house and it's stranded right at the tide line, mean high tide, and its septic system, the way it's going to have to be sited, is in fact going to discharge wastewater across the beach and in fact transect the public trust. Can the state deny a new septic system permit to that house if the septic system is destroyed on public nuisance grounds?
Yeah, I'm not sure exactly where you're locating it.
So let me clarify it. So it's property that has been above the mean high tide, and during a major storm like Sandy, the septic system is destroyed and exposed and all the pipes are broken off. Can the state deny a new septic system to that house, essentially deny it the right to rebuild, if that septic system now has to be situated, say, below the mean high tide line on the wet beach?
again, I wouldn't take that case. That's not the case that we're concerned about. What we're dealing with in all these cases is what I would consider expanding public rights to where they haven't been before, and then at the expense of these private property owners that have lawfully built homes have to subsidize public access on dry beach land that has never been subject to public use. So there are all kinds of different scenarios. Nuisance, then you have a Lucas scenario and setback, but none of these cases really deal with that. And we're fairly selective. You might know some of our cases: Palazzolo versus Rhode Island, Nolan versus Coastal Mission, Sackett versus EPA. So the reason we're taking those cases is because, in our opinion, the push is too far the other way.
I'm sorry, we could talk about any one of these topics the rest of the afternoon, but we have lots more to get to. We have two great panels waiting to share their presentations with you. Please join me in thanking David Breemer.